Good afternoon and welcome. We're pleased to have all of you with us this afternoon. We have 4 cases on the afternoon docket, which we will hear in the order in which they appear. Let me remind counsel that each side has a total of 15 minutes to argue, and that applies whether there's one of you or several attorneys on one side. If there are multiple attorneys, then you will have to share that 15 minutes. Also, the appellant has the right to reserve up to 5 minutes for rebuttal. So when you come to the podium after you've introduced yourself, let us know how much time you wish to reserve, and the clock will be programmed accordingly. Are there any announcements or introductions? Mr. Kozlowski, please come forward. Good afternoon, sir.
Thank you, Judge Clement, members of the court. It's my pleasure to introduce my colleague, Patricia Sellers, to the court. This is her inaugural argument before the Court of Appeals this afternoon. Ms. Sellers is a long-term resident of Marshall County, graduated from Marshall County High School. Following obtaining her bachelor's degree at the University of Tennessee at Chattanooga, she, for some reason, returned to Marshall County and taught for a number of years at the Marshall County High School. Then, again, for a reason I'm not quite sure I can explain, she decided law was her chosen profession, and she graduated from the National School of Law in 2020 and has worked with the Legal Aid Society of Middle Tennessee in our Columbia office since then. I appreciate you welcoming you to the court.
Well, very good. We're pleased to welcome you and look forward to your argument.
Thank you.
Thank you, Mr. Kozlowski. All right, any other announcements or introductions? Hearing none, please call the first case.
James Henry Whitaker II versus Viktoria Moor.
Good afternoon.
Good afternoon, Your Honors. May it please the court, Ben Lewis from the Rutherford County Bar on behalf of the appellant James Henry Whitaker II. At this time, I would request to reserve 4 minutes for rebuttal, please.
4 minutes, yes, sir.
Thank you, Your Honor.
And this is our Rutherford County Day. You're the third Rutherford County case we've had, so we're going to put a cap on these things.
Okay.
So you're just lucky you snuck in under the cover.
Glad I could spread it out across the day for you. Your Honors, again, I represent the father in this case, James Henry Whitaker. This is an appeal from a ruling of the Lincoln County Chancery Court in a matter regarding a relocation case and a modification of a parenting plan. We present one issue for the court today, and that is whether the trial court erred and abused its discretion by granting the mother's request to relocate to Germany with the minor children, 2 females, and finding that the same to be in their best interest. These parties were divorced in 2018. They have 2 children together, 2 young girls, and through that divorce proceeding, the father received 144 days under the permanent parenting plan. Father filed in 2020 seeking a modification of that parenting plan to revise it to an equal shared parenting schedule of 50-50. At that time, he had changed jobs. He was able to do more. He was working at home due to COVID, and he was requesting equal time with the mother. They were close in proximity to each other, and he felt he could do that. Mother, at that time, countered father's petition and asked for a relocation to Germany, where she was originally from. She had moved to the United States, gotten married to father, and had 2 children with him, and in their divorce proceeding in 2018 had also requested a relocation to Germany. It was denied at that time, but she renewed that request when father filed his petition. In August and September of 2022, the parties had a trial that spread out over 4 separate days, I believe, including the ruling, including closing arguments. And in November of 2022, Chancellor Cox of the Chancery Court in Lincoln County issued a ruling granting the mother's request to relocate to Germany and fashioning a parenting plan that gave the father on paper 90 days, although it states specifically in the parenting plan that it is only for child support purposes. The actual particularities of that plan were that he would receive the breaks fall, spring, and summertime, and some at Christmas time as well. Your Honor's understanding that
I think you're arguing that the father only received 60 actual days?
Correct, Your Honor. 60 days is
but 80 was used for child support purposes.
90, I believe.
Excuse me, 90.
90 was used for child support purposes, but it's denoted specifically it was child support purposes only. Admittedly, this is a difficult case, as any parenting plan case would be for the court. While the court is required, a trial court is required to fashion a parenting plan that maximizes the parenting time of both parents, that is admittedly difficult in the instances of a relocation. I don't doubt that if this court upholds relocation, that Chancellor Cox likely did all he could to give what he could to the father in terms of what breaks might be there. However, our position is the proven trial was not sufficient to uphold, or for this court to uphold, the decision of the trial court to grant a relocation to mother. One of the main reasons being is that the father had a significant amount of parenting time with these children, 144 days, was seeking more time and could do more time with these children, and instead the court took that time away from him as one of the factors in 366108 talks about maintaining the relationship of the parents, and took that time away from him and then ultimately saddled him with 80 days less, 80 plus days less. But this court is required to find, in order to overturn that decision, an abuse of discretion, which is a high burden, admittedly, for my client to overcome. Under 366108, there are several factors that the court is required to consider in conjunction with 366106 of the best interest factors to determine whether or not a relocation as requested by a parent is in the best interest of the minor child.
One of the best interest findings that the trial court made was some animus by father and his mother against the children's mother. They would say bad things about her in front of the children, and they both tried to get her fired from a job which she needed to support her children. Those are pretty serious findings.
They are, and my client, respectfully, Your Honor, did not see that the same way, and I think testified very strongly that that wasn't the way that he intended any of this to go. He did not call her work to get her fired. He called, I believe, the police department to inquire about that when it did come up, but he was concerned for the safety of his child, that she was being left at Walmart unattended for an entirety of a day while the mother worked for 8 hours. While admittedly the court did hold that against him and found that to be a significant factor, in conjunction with his mother, I believe, doing a similar action of calling maybe an ethics hotline with Walmart or something of that nature. Neither of them called directly to the store and said, this is occurring, please have her fired or something of that nature, or there's some issue with it. They sought to see whether or not it was appropriate within the framework of what Walmart's regulations were and the law to decide whether or not to take any further action. I don't think they took any further action after that.
Prior to father contacting mother's employer, did he try to contact mother and say, I can pick up the child if you don't have child care for did he resort to anything prior to contacting the police?
The issue that came up with this instance, if my recollection serves, is that the mother had initially asked father, or father had inquired with her whether or not she needed assistance during this time. She had said no. Father had made plans at that time to go, I think he was out of town or something of that nature, and then mother contacted him later and became upset with him for not being able to help her with her time while she had to work. At that time, she took the child to her work, left the child there unattended during that time in a break room. And if my recollection serves, I was not trial counsel, but I believe that he did send an email to her at some time about that, but he did not receive a response, which if you look through this case, Your Honor, is a consistency between these parties, both of them, that they don't communicate well with each other. So the lack of communication would make sense, but I do believe something was sent to her, but I don't think that there was necessarily an attempt to walk up to Walmart and seek her out and see whether or not that was the case. But I would also point out that he did not directly contact her store or her supervisor or her employer directly to do that. He contacted the police department to inquire about it, and no one went there, no police officer went to the Walmart, to my recollection. On the issue, the first factor that's for consideration under 108 is the nature, quality, and extent of involvement and duration of the child's relationship with the parent proposing to relocate and with the non-relocating parent, sibling, and other significant persons in the child's life. The court found specifically under that factor that mother has an outstanding relationship with the children and a stronger relationship than father does. It's our contention that there's no factual basis for the court to determine that within the record. The children did not testify, although there were statements of the children that came through the counselors, one of whom, Ms. Crystal Guess, who testified at the trial and submitted her notes that both parties had on frequent occasion requested and actually subpoenaed from the counselors. Her testimony was that both of these parties had involved themselves significantly in the counseling of the child. The oldest child, Bella is her name, had inquired significantly, requested notes, and had actually put in her notes that her feeling was that both parents were attempting to essentially cross-examine the child based upon what she said during her counseling sessions. She ultimately terminated her counseling relationship with the minor child based upon both parents becoming involved in making these requests. And she noted specifically, which I find to have been glossed over by the trial court, she stated specifically that both of these parents contributed to the lack of co-parenting between them. It was on both of them. As to what the minor children said, or the minor child, the oldest minor child said, she specifically said that she wanted equal parenting time with her children and that she wanted to see, or with her parents, and wanted to see both of her parents. The court did not put, in our position, significant weight upon what the counselor said, although the court does put significant weight on other statements that the children make throughout that. Going back to what Your Honor mentioned of these derogatory statements, the only derogatory statement other than what mother claims, which would have been hearsay from the child, the only thing that the mother claims was said was a comment made about the child's hair from the grandmother, and then a conversation that the father supposedly had with the child that the counseling notes note that her dissatisfaction, the minor child's dissatisfaction with that conversation between father and her was not based on what was said to her, but what was because she missed her shows. She didn't want to have that conversation because she didn't want to miss time doing what she wanted to do. So the record shows there was significant misconstruing of what these statements were from the mother in her attempts to say that father was talking derogatorily, when in fact the records from the child in those notes with the counselors do not suggest that there were derogatory comments made, other than something about the child's hair at one point that I think was said by the grandmother. In addition, the court found under this factor one that the mother's whole family was in Germany. However, significantly, no member of mother's family testified. The children had not been to Germany since 2019, and there was no testimony whatsoever ever regarding the extent of involvement the minor child had with the mother's family while they've been there. On the contrary, father had a good relationship with the child, or with the children, is what the court said, and it also noted that father's whole support system was here. However, later in the ruling of the court, it appears to flip that on its head and say that mother's relationship with her family in Germany is going to benefit the children, whereas father already had that here in the United States.
You mentioned the children had not been to Germany since 2019, but I garner from the mother's brief here that the children have moved with mother in July of last year, so they've been there over a year.
They have.
What role should that play in the determination here, if any, that they now have spent over a year in Germany?
I would submit, Your Honor, that should not play a role in this court's determination as to whether or not the court got it right at the time that the decision was made. If that was the case, there has been protracted litigation over other issues surrounding this parenting plan since it was issued, including whether or not father has received his parenting time. So if that issue is going to come into this court's consideration, then I think it would be appropriate to also consider the other facts. But I would submit that the children being there now for a period of over a year plus should not make a bearing upon whether or not the trial court made the correct decision at the time that it made it. And I will concede my time for now until my rebuttal.
Thank you, Mr. Lewis. We'll hear from you on rebuttal. Mr. Underwood, good afternoon.
Good afternoon, Judge Clement. Good afternoon, Court. Tim Underwood with Giles County Bar for Viktoria Moor, the mother and appellee in this case. I usually don't start these kind of arguments with the standard of review. I know the court knows the standard of review, but I think it's important in this particular context because 36-6108 was amended, as this court knows, in 2019, and it changed drastically how we litigate relocation cases in Tennessee. By my research is when I filed my brief in April, there was 9 cases that had been decided by this court, all of which affirmed the trial court's decision, whether it granted relocation or whether it denied relocation. There was a 10th one that came out, and I may be pronouncing this wrong, but it was Kalaja versus Bradfield that came out right after we filed the brief in this case. And so that would be the 9th case that came out, and it again affirmed the trial court's decision on relocation. And the reason that's important is we go all the way back to the second case that I think was decided under the statute, Dungy versus Dungy, and both of us cited that case in our briefs. And the holding in that case indicates that that this new legislation restored a significant amount of discretion to the trial courts. And that's important because it's an abuse of discretion standard. And I agree with Mr. Lewis. I think he has a heavy burden. It's not that we have a fundamental disagreement about this case, obviously, or we wouldn't be here. But I think it gets back to the fact is that the father's complaining about something that he doesn't like and doesn't want, but he never proves an abuse of discretion. And the abuse of discretion standard is either an incorrect legal standard that was applied by the trial court, or it resolves the case clearly on erroneous assessment of evidence, or relies on reasoning that causes injustice. Dungy goes on to add to that is there's a presumption that the trial court's decision is correct and should be viewed in the light most favorable to that decision. And that's significant because of what this court has done with cases since 2019. Again, there's been a litany of cases that this court has affirmed the trial court, but we have to look at it as to what this court did and what the trial court did to mirror those opinions is. And I would submit that the trial court outlined its rationale, its reasoning exactly like those 9 or 10 cases that this court has decided since 2019. It was a 16-page opinion that this court did. It did exactly what this court would expect of a trial court. It made very sufficient and specific findings of facts and conclusions of law, and it went through each particular factor and analyzed those factors in regard to the findings of facts and conclusions of law that it made. And the court followed what I would consider to be the opinion of this court in Michaela versus H, which is it didn't do just a rote examination. And I think what this court meant by that is we don't just look at these particular cases like a scorecard. We don't sort of tally up the number of fors and against, and we make a decision because there was 4 for it and 3 against it and one didn't matter. That's not what the court did. It examined every single particular factor, and then at the end of that, looked at it from the totality of the circumstances and applied all the factors in general and came to the decision that it believed that the circumstances favored relocation as being in the best interest of the children. And going through those particular factors as it relates to 36-6108, some of them do overlap, but it appears to me that the court focused primarily on factor A and E. A was the relationship of the children with each particular parent about that is. And the court went into, I think, great detail about what was going on in the household with the father and what his relationship was, not only with the children, but also as it relates to the mother. And so A and E sort of interact because it's relationship of the children and whether it's promoting or thwarting the relationship of the other parent about that is. And so as Judge Clement, as you pointed out, is the court made a significant finding that the father and the paternal grandmother were attempting to get the mother fired from her job. I think the question was, Judge McBriar, you asked, was there something that was offered to the father about it? I think the testimony is that the mother had to take the child to school or to work because she didn't have any other opportunity to have a babysitter, and offered it to the father. He declined and then made a report to the police. I do think the record shows that the police actually showed up at her employment to be able to do that. So the court was concerned about that relationship between mother and father and that how it was indirectly impacting the relationship of the kids. There was also testimony that father was interfering with the babysitters of the mother. She felt like that the babysitters were being intimidated or harassed by the father and not being able to maintain those. The court also heard testimony from the counselors about negative comments that were being made at the father's homes. And this was counselors who were experts in their field as it relates to juvenile trauma that were testifying that not only was the child honest and forthcoming and not being coached, but mother was being portrayed as a negative and father was being portrayed as a positive in those, and that the child was being punished for not saying what was happening at mother's home when father was asking. And so the court goes into a little bit of detail about these influences that the father was having over the children, and specifically the paternal grandmother about that. And there was testimony is that father had now sort of, what mother testified was gaslighting tactics against her, was now sort of being transformed into these issues as it relates to the children, and that the father was denying regular medical care like a tonsillitis, or going to an eyeglasses appointment for a dentist or orthodontist consultations. Is the court was seeing that as being negative influences that were happening in regard to the children. The father even testified at trial, admitted under cross-examination, is that he objected to extracurricular activities, such things as sporting events, is that he said that mother could do these particular sporting events, but there was no way that a game or practice was ever going to occur on his particular time. And this had a culmination effect of it is, and I think this gets back to factor A as to who had a better relationship with the children is, and despite what the counselor said that this was an honest child, she was forthcoming and not being coached, both the paternal grandmother and father testified that the child was a habitual liar. And that he didn't have enough time in the court proceeding to tell all the many lies that this particular child made. And it was in context with the child not reporting what was going on at mother's house, saying negative things about him to the counselors, and this culminated with this eldest child having a school project that many kids have is that you go home and or at school you draw a portrait of my family, and it didn't include the father. And the father was extremely upset about that. And so you can see that the court, when it considered the outstanding relationship of the mother with the children, it had sufficient evidence to be able to do that. The next factor that comes into play is the age, development, state, and impact of relocation on the children. And I don't think there's any disagreement in this case that these children are strong students. They are emotionally equipped. They're well regarded. The counselor had nothing but nice things to say about the child that it did interview, and that these children are favored relocation under this scenario, and that the children are dual citizens.
I mean, is it fair to say both children favor it? Was it just the older child that expressed an interest in moving to Germany?
It was only the oldest child that was subject to the counseling. That's correct, Judge.
Yeah, I think the thing that concerns me, and the father pointed this out in his brief, if there seems to be some factual findings that I'm not sure were supported by the testimony here, and perhaps you can explain to me where this comes from. For example, the court finds that the children could cope with the challenges that the German schooling might bring. Where does that come from? Is that solely from the counselor's testimony? And if so, where do I find that?
Judge, I think it comes from, and I can't be able to, and I apologize, I can't cite to the actual record that exists on that particular fact is, but the court made reference to the fact is that these children had dual citizenship. They spoke German in the mother's house, and there was existing relationships that existed in Germany from mothers prior to moving here. She had an established family there, and the court mentioned again that the children hadn't moved, but had visited to Germany on several different occasions, and I think even the existing permanent parenting plan even outlined some visits that were to occur in Germany during the summer during her time. So I do think that there are grounds for there being sufficient ties to Germany, if that answers your question appropriately. So the court found that factor favored relocation as well. Then the next factor is factor C, that's a suitable visitation arrangement if relocation occurs. I would submit to you is that father didn't appeal the permanent parenting plan that he was given. That's not the issue before the court. The issue is that he objects to the relocation. He doesn't actually object to the permanent parenting plan that the court implemented. And that actually went above and beyond as to what the mother offered. The father seems to indicate that that this factor should be the sole factor of everything. And it cites in its opinion is that Dungy versus Dungy. And the only similarity between Dungy and this particular case is the two countries that are involved in that. And so the Court of Appeals in Dungy considered factor C to be a neutral factor in that particular case and I think that case is distinguishable from this case because the facts are different. The child the child actually did testify in that case that he did not want to go to Germany. He did not speak German. He always wanted to live with a relocating parent rather than with the parent that was moving. And so I just don't think there's any similarities that come from that. Dungy does reference Hall versus Hall, and I think this gets into a discussion when we have a relocation case that goes 50 miles or beyond, oftentimes the courts have no other alternative but to find a permanent parenting plan that is based upon visiting during holidays. And so to a certain degree I don't know that there's a lot of difference between moving from Tennessee to Germany or moving from Tennessee to California or Tennessee to New York or Tennessee to Florida. We're still going to have to make up those times during holiday periods. The next factor is children's preference. Neither one of these kids testified at trial. They were 12 and 8, and I think the statute speaks to being 13 to be able to testify about that. And the court found this to be a non-factor. Somehow the father seems to find fault with that. The father argues in his brief that this really was a factor that was considered by the court. He just didn't say it. And I don't believe there's anything in the record that would substantiate that. The court did mention that the counselors testified that one of the children had a preference. The mother testified that there was a preference, but there was no objection. What the court found that to be a non-factor about that. Which brings us to factor E, which I think is one of the most critical factors that the court considered, and that was the promotion or thwarting of a parent's relationship with a child. And in the brief, father argues based upon the statute there should only be a consideration of the behavior of the parent that's relocating. And I would submit to you that that's not consistent with what the case law is, especially not the recent case law that I have reviewed. Key versus Gonzalez in 2024 and In re Michaela H in 2023 both did a comparative analysis. So looking at both parents is appropriate, and the court did that in this particular context, much like a comparative fitness analysis by the trial court. In addition to the things that I mentioned before about calling the police at work and trying to get her fired, the father also did call the police for welfare checks at the mother's home because there was an allegation of a bruise because of a trampoline incident. He called her sick and psychotic for the mother helping a child bathe to get grass out of her hair. So in essence, there was plenty of evidence that the court had to look at who had a better relationship and who was promoting and who was thwarting a relationship. In fact, one of the counselors testified to that degree that she heard mother tell the eldest child that was in counseling that I support your relationship with your father. I support you maintaining that relationship. I'm encouraging you to have a meaningful relationship with your father. So when you do those comparisons, it clearly is one that
who overheard that?
It was the counselors testified that's through her sessions that she heard that testimony.
All right.
Okay.
You've asked for attorney's fees on appeal, but the court here told each party to bear their own attorney's fees.
That's correct.
I mean, I know F allows for attorney's fees, but my presumption has always been that only occurs after a trial court perhaps has awarded them below. Have we ever had a circumstance that you've been able to, or you can cite me to, where the trial court has denied a request for attorney's fees, and then the appellate court has said, no, we're going to grant them on the appeal only.
Judge, I think it's 366106F, if the subsection is correct about that is. I think it allows for it under there. I understand what the concern is for the court about it is. I think we get back to the record on this particular case about what all it took to get the record here before the court, and different things that went on as it relates to that is offering a transcript that was recorded by a cell phone that was filed as a transcript rather than a statement of the evidence. It had numerous errors that were in it. The court found it to be unfair, to be incomplete, and so that's why we were asking for the attorney's fees. I could not find any cases that support that, but I did not think that it was a frivolous argument to be able to ask for it based upon 366106F, or 108F, I apologize.
All right, thank you, sir.
Thank you.
Mr. Lewis?
Yes, Your Honor. Touching on that last point, when it comes to the record that's before the court, there's been mentioned several times of errors within the transcript or the statement of evidence. However, there was never once a single error pointed out by opposing counsel in the record or the statement of evidence. Essentially, when the statement of evidence was made, it was the transcript that was previously attempted to be provided was taken, put into a Word document, and submitted as a statement of evidence, along with what had been accepted as mother's portion, without alteration. So there were not errors to it. It simply was an effort, in my opinion, to try to thwart the father from being able to create a record. And ultimately, this court had to issue an opinion and a ruling in this case to the trial court to create a record because it refused to do so. So I would submit that that there were no errors in that record to begin with. Touching on the cases that Your Honors talked about and the opposing counsel talked about regarding relocation under the new statute. In Dungy, that there is a similarity between the countries, Germany and Germany. That's really, I think, the only case this court's considered where Germany was involved. And in that case, correct under C, that the court stated that the logistical and financial challenges in maintaining visitation for the non-custodial parent when the parents live on two different continents is enormous. The difference, though, was the court in that case found it to be an equal factor between the parties, but both parties testified essentially that, hey, if the court grants this, we'll do our best to make sure that each of us does what we're supposed to. That wasn't the feeling, I don't think, that the court got in this case between these parties, considering that they had already not effectively co-parented at this time. Going back to the child's preference issue, we do bring that up, Your Honors, and the reason we bring it up is that there are multiple times within the court's ruling where it does state under this section that no preference testimony was taken, nor should it have been. However, it then notes in its factual findings that the children have indicated a desire to move to Germany.
Well, shouldn't we read into that then, that the court found that but decided it wasn't appropriate to consider?
I have a hard time thinking that if it's being placed within the order as a factual finding, that the court found the children.
But don't judges do that all the time in bench trials? They rule on an objection, sustain the objection. They've heard the objectional evidence or offered evidence, and then they don't consider the final opinion. I mean, to me, that happens all the time in a bench trial.
But the issue is he put it into the final opinion as a factual finding. That's the distinction, I think. If the court hears the evidence on making an objection and then doesn't ever consider it again, that's one thing. But for the court to hear it, know that it shouldn't consider it because these children aren't 12, and then to place it multiple times within a final order that they have a preference to move to Germany that was given through other means, that's the reason why I think it is a distinction in this instance. And then the issue of, going back to what Dungy states, the issue of the feasibility of maintaining the relationship, in my opinion, it's not possible, and it hasn't been possible if the court was to consider what's happened down the road. But I do submit that should have been the biggest factor this court considered, was whether or not it can maintain a relationship between the parents. Our statutes state that the court should maximize parenting time with both parents. And in making this parenting plan, while yes, if this parenting plan is going to stand, I think that the breaks are all that father can get. It's not feasible to send a kid over here for a 2-day weekend. It's just not. But at the end of the day, the court should have considered this factor on whether or not can it maintain a schedule that the parties can do, but can it maintain the relationship with the father? And he had been exercising 144 days a year and went to 60. And it's our position that in light of the evidence that was presented to the court had several other means available to it other than to grant a relocation to Germany, and we submit that's an abuse of discretion. Thank you.
All right. Thank you, Mr. Lewis and Mr. Underwood, for your arguments. We will take this matter under advisement. Call the next case, please.
In re